नमस्कार दोस्तों। रूल 86A of the CGST rule is creating a lot of problem for the businesses in India. And especially the GST department blocks the input tax credit without providing any opportunity of being heard. They do not give a show cause notice before blocking my input tax credit. They simply put a blanket ban on my input tax credit without even intimating me that they are going to block my input tax credit. My working capital for the business is going to be blocked or freezed for the months together, you can say for at least a year. And it was creating a lot of chaos and troubles for the businesses, and even high courts were not giving any relief on this issue. So recently I came across a judgment which is very pragmatic judgment, and you can say it will be a very celebrated judgment by Honorable Supreme Court of India. Honorable Supreme Court has upheld a Karnataka High Court judgment wherein the single judge denied the pre-decisional hearing in case of Rule 86A. The division bench reversed the decision of single bench in the case of K9 Enterprises, State of Karnataka versus K9 Enterprises. And the DB held that pre-decisional hearing is very mandatory in case of Rule 86A. The principles of natural justice which were enshrined by the Honorable Supreme Court in case of Maneka Gandhi versus Union of India are now reiterated by Honorable Karnataka High Court, which is subsequently upheld by Honorable Supreme Court. So principles of natural justice is a very you can say is the backbone of the GST statute. You are punishing a person or a business without hearing him at least. You have to give him the opportunity to explain whether this input tax credit was obtained fraudulently or otherwise. I may have certain justifications for that. I may have certain evidences to substantiate my claim for input tax credit. But you are not hearing to me. You are simply passing a ban. You are simply putting a ban on my input tax credit even without hearing my version that what I have to explain. And this has been upheld by Honorable Supreme Court, and you have to remember it's SLP number 11543 of 2025, wherein the original decision was passed by Honorable Karnataka High Court in case of State of Karnataka versus K9 Enterprises. You can read the judgment of Karnataka High Court, very pragmatic judgment and very important in your future endeavors. So I hope now you can easily defend Rule 86A on the grounds that it is clearly violative of, you can say, the Article 19 and Article 21 of Indian Constitution. Thank you very much for watching this video. Have a nice day.